everybody. This is Advocate Lucinda, your empowerment lawyer. Today, we're going to talk about sanctions. The court issuing sanctions against an attorney, which would include pro se. And there are three powers that the court has. The first one is inherent power. The second one is Section 1927 power. And the third one is Rule 11 power. And just as attorneys, including pro se's, have to make out a prima facie element for whatever cause of action is before the court in issuing sanctions is required to make findings of facts and conclusions of the law. So let's get started. So let's look at inherent power. And this is the legal definition. Inherent power is governed not by rule or statute, but by the control necessarily vested in courts to manage their own affairs so as to achieve the orderly and expeditious disposition of cases. Now, what does this mean? First, unlike the other two powers, this power is not governed by statute. So the judge bases its decision on whether to issue this power from their experience. Their experience being lawyers, their experience on the bench. And the Supreme Court has cautioned because this inherent power is so potent in that the judge has unfettered discretion, it needs to do its due diligence before they issue this power. This power requires a showing of bad faith or of conduct tantamount to bad faith. And to illustrate this power, we're going to look at Roadway Express Inc. versus Piper. This case has to do a lot with discovery. The plaintiff's attorney sued on behalf of his clients an employment discrimination claim. And there was a lot of misconduct in this case. For example, Roadway responded to the plaintiff's complaint and subsequently served interrogatories on the plaintiff. Well, the plaintiffs did not respond to the interrogatories. Not only did they not respond to the interrogatories, they did not answer discovery, they did not appear at deposition. They just didn't respond to deadlines. And as a result, Roadway's attorney filed a motion to dismiss the lawsuit. The court did dismiss the case with prejudice, and the judge ordered the attorney to pay petitioner's costs and the attorney fees for the entire lawsuit. Now, of course, the court issued the sanctions against the attorney or ordered that the attorney pay the attorney fees for the other side based on bad faith, because it does appear that the attorney was not cooperative in some instances as well as his clients. On his face, it just sounds like a bad faith situation. But what do you think? The Supreme Court found that the trial court did not make a specific finding as to whether counsel's conduct constituted or was tantamount to bad faith. the court did not write in its order what its findings were to justify the sanctions. In other words, before a court issues sanctions, the court must find specific facts. So remember that. And also, let me say, in other cases where sanctions are not the issue, you would want to ask the court to make findings of fact and conclusions of the law in your case. And it's always good to read local rules or jurisdictional rules to know its protocol regarding the court to make findings of fact and conclusions of the law. Section 1927 provides for imposition of excess costs, expenses, and attorney's fees on counsel who multiplies the proceedings in any case unreasonably and vexatiously. It requires a showing of bad faith with recklessness, frivolousness, or with the intent to mislead the court. So let's look at Wavetronex LLC versus Myers to illustrate this sanction. In this case, the attorney, Atkins, represented the company, Wavetronex. It was a bankruptcy case, and Myers was appointed as the trustee for Wavetronex. And of course, as a trustee, it was his duty to liquidate the interests of the company. In the interim, Wavetronex's attorney filed a lawsuit against the trustee. The attorney did not seek leave of bankruptcy. They accused that he was stalling off the trustee's efforts to liquidate the assets. And as a result, the court issued Rule 11. Subsequently, the attorney Atkins filed a motion for reconsideration. And then the court issued 1927 sanction against him. So what do you think? Or is the sanction justifiable? The appellate court found the district court failed to present facts to support the 1927 sanction. Here we go again. The court must make the findings of fact. A Rule 11 sanction applies to the attorney's signature on papers filed with the court, which represents that the filing is not being presented for any improper purpose, that the claim is warranted by existing law or non-frivolous argument, that the factual contentions have evidentiary support. In other words, attorney or pro se, by signing the complaint, you are representing that the filing is for a proper purpose, that it is warranted by existing law, or you have law to justify your position. That's why I always say, going into a lawsuit, you need to know your facts and you need to know the law that you're going to rely on to make your case. And that the factual contentions have evidentiary support. In other words, you got support. And this, in Rule 11, requires a showing of being frivolous, unreasonable, or without foundation must be demonstrated. So to illustrate this sanction, we're going to look at Ortlet versus Cincinnati Microwave Inc. And in a nutshell, CMI accused Ortlet's attorney of just a list of things that he did or he did not do. Well, what do you think? Here we go again. The appellate court held the district court's ruling lacked support, and the court remanded the case to the district court. And one other thing I want to say before I end this video, where sanctions are issued sua sponte, and sua sponte is when the judge decides to issue sanctions on its own volition. The court must issue a show cause order before it sanctions. Hey guys, I hope this has been helpful, and we'll see you next time on Advocate Lucinda, your empowerment lawyer.